Hello, everybody. Good morning. Welcome to DRIF22, day 2. Day 1 was very insightful and very interesting. We promise you a very educative and interesting session today. We're kicking off with
Vamos começar
our panelists from Usmanu Danfodiyo University, Sokoto, Nigeria. We have Usmanu, Alito in Smart, Toyid, Timothy, and they will be taking us on
Good morning, everyone.
Bom dia a todo mundo.
So you have the floor, our panelists from Usmanu Danfodiyo University.
Good morning, everyone.
Bom dia a todo mundo.
It is a great pleasure to have you here.
Uma prazer estar com você.
The session is on Unpacking Fundamental Rights online.
Sobre direitos fundamentais.
And we have four panelists. So others will join from. They are on their way. So I will start the session.
Outras pessoas vão juntar daqui a pouco.
When we see Unpacking Fundamental Rights online, what this means is that our job is to examine the presence or the application of fundamental rights in digital space. What is fundamental human rights? Fundamental human rights are those essential human rights. These rights that are inalienable, that is given to every human being by virtue of being alive. I believe everyone in this call has been coming across the phrase fundamental human rights. So there's no need to dwell on it much, but we are going to talk about brief history as to the application of fundamental human rights before we move further. So fundamental human rights came alive in 1948 after the Second World War. So this right came alive through Universal Declaration of Human Rights by United Nations as a response to the event of Second World War. Though through UDHR, these rights are not binding, as in the application of this right are not binding on the states. They were just seen as a persuasive tools, like something persuasive to states to apply it in their respective jurisdiction. So it took time before this UDHR later formed part of Customary International Law, because in international law, we have several sources of international law. We have treaties. One of them is the UDHR, and also the second source of international law is Customary International Law. Customary International Law, it means the rules, the doings of state, which will now become habitual doings, in which every state is banned, though it might lack element of action, but every state is banned by courtesy to apply it. So until the year 1966, it was when they give element of enforceability to fundamental human rights at the international space. That was what led to the enactment of International Covenant on Civil and Political Rights, ICCPR, and International Covenant on Economic and Social and Cultural Rights, ICSR. So these two covenants were adopted by United Nations, and this made it the effect of the application of these two covenants is to give enforceability. That is, the fundamental human rights were not just seen as persuasive. States are mandated to apply them, to domesticate them within their jurisdictions. So let's now talk about online. Online here simply means to be on the internet. The internet in its simplest meaning is a fast network of interconnected computers. For example, a website we said to be online if it is on internet. So for example, the Zoom we are using now, we are using it because it is connected online. So that is online. So our work is to examine fundamental human rights internationally and domestically as they are applicable on the internet sphere. I've said it already. So what is fundamental human rights within our jurisdiction, within Nigeria legal framework? Fundamental human rights is basically enshrined under Chapter 4 of the Constitution. And these rights, though every citizen of Nigeria are expected to enjoy them, they are expected to have access to them without any without any limitation. But as we know, rights are not absolute. There are certain restrictions placed upon the application of these rights. So, for example, we have freedom of right to life that is protected by Section 33 of the Constitution. So, but as this discussion is concerned, we are not bothered about all those rights. We are going to be specific. So, those rights that are so concerned to this discussion are privacy and data protections, access to information, freedom of expression, freedom of association and assembly, and freedom from discrimination. So, what I mean by privacy and data protection is every citizen of Nigeria are expected to have freedom as they have rights for their data to be protected online without any interruptions, without any unlawful interference. So before 11th of April, though there is no specific legislation that talk about in our constitution that talk about protection of privacy, or let's say data protection. But Section 37 of the Constitution, if it is being interpreted in its holistic form, we could say it has covered this aspect. And thank God now, as I'm speaking, we have a judicial blessing as to this effect. This happens. There is a case. There was a case that was reported against Zenith Bank that the Federal High Court in Ogun State awarded 5,000 naira against Zenith Bank. What happened in that case was that Zenith Bank continued to send spam message to a person who is not even their customer, and the person felt that his right has been infringed. He approached the court, and through a legal team, the court eventually awarded 5,000 naira in favor of the client. So, though the money might look so mega, but the implication of this decision is that there is it established judicial precedent for this kind of issue. And also there is a case that happened in the year 2018, the case of Emerging Markets Telecommunication Service Limited versus NEA. This case, the Court of Appeal made the decision that unsolicited SMS text message is a violation to fundamental right to privacy. So these two decisions could be said to be a basis for protection of data privacy, and to say that data privacy is a fundamental human right to every citizen of Nigeria. So let me digress from legal framework. Let me talk as a journalist as well. There was a story I'm doing particularly. As I'm doing the story is on how online fraudsters are Sweden's victims account through Sporty Bet platform. So when I interviewed some victims, let me realize that online fraudsters will treat them and they will access their Sporty Bet platform, and through the the unlawful access, they will swindle all their account. This is a perfect example for unlawful interference to data. So another legislation that protect data, I think Cybercrime Act of 2015 also is useful in this regard, because Cybercrime Act of 2015 prohibit and prescribe any form of cyberbullying or cyber offenses. And also another legislation that is so relevant here is NITDA regulation 2019. So NITDA is empowered, is a governmental institution in Nigeria that is empowered to protect data and make sure all data are safe. So now I will move to the next rights here, that is right, access to information. Access to information, even though there is a domestic legislation here in Nigeria that specifically deals with it, that is Freedom of Information Act of 2011. There are people still feel reluctant to apply this kind of law, maybe because of the clause of urging every state to domesticate same before same could be said to apply in their jurisdiction. So we have freedom of expression. Freedom of expression, whether online or offline, it's enshrined by the Constitution. So I have the right to express my thoughts. I have the right to express my opinions, both online and offline. So for example, for Twitter users like me, if I immediately I tweet, what I'm doing is I'm expressing my fundamental right of expression. And also I have freedom of association and assembly. Let me use WhatsApp as a basic as an example here. The fact that I have the right to belong to a particular WhatsApp group is like this is a replica of my freedom of association. If I feel like I can say I'm leaving a particular WhatsApp group today, that is doing that I'm exercising my freedom of association, and also freedom of discrimination. So freedom of discrimination, this freedom is protected both online and offline. In fact, the law that protects disability rights, that's 2019 or 2018 law, also helps in this regard, because it tries to protect the right of disabled people. So in all, there is a particular international framework that made every fundamental human rights that are applicable online to be applicable that are applicable offline to be applicable online also. In July 2012, 85 countries signed a United Nations Human Rights Council resolution that led to Sweden affirming that same human rights that are applicable offline, they are also applicable online. So, as I said earlier, these rights are not absolute. There are certain limitations. There are certain restrictions that are available for this for the application of these rights. These rights are not absolute per se. So these rights are not absolute per se. Section 39 sub 3 of the Constitution of the Federal Republic of Nigeria stated clearly that this section shall not invalidate any law that reasonably justifiable in a democratic society. So what this line of Constitution is saying is that if there is any law that is made to promote our democratic ethics, so the provision of the application of these fundamental human rights will be exempted. So, and it enumerates certain instances. One of them is for the purpose of preventing disclosure of information received in confidence, maintaining the authority and independence of courts, or regulating telephone, wireless, broadcasting, television, or exhibition of cinematograph film, or imposing restrictions upon person holding office under the government of the federation or of a state, members of the armed forces of the federations. So now this section 39 sub 3, it's like it is like an exception to section 39 of the Constitution. Why section 45 sub 1 is the, as lawyers call it, is the law that is the section that provides limitation to application of all fundamental human rights, starting from right to life, from section 33 to 42. This section is an exception to the application of all these fundamental human rights. And this section provides that nothing in section 39 shall invalidate any law that is needed. I've said that. It stated that these fundamental human rights will be exempted in the interest of defense, public safety, public order, public morality, or public health, or for the purpose of protecting the right and freedom of other person. So as we know that where your own rights stop, the right of another person begins. So I cannot say because I have rights, I should start infringing the right of another person. Fine, I have right to freedom of expression, but I should not do something that will lead to the infringement of another person. For example, I say I have rights. I have freedom of expression online. So if I start bullying someone online, it will lead to cyberbullying, and that person can sue me for infringement of his right to human dignity. And this is exactly what happened in the case I cited when Senate Bank were sending unsolicited message to the client. They thought they have the right to do that, but they don't know that doing that is an infraction to right to privacy of the client. So I think the panelists should be online. I want to check if these guys, my co-panelists are online so that they can take it from here. Mr. Tawid, are you on, please?
All right, good morning, everyone. Can you hear me, please?
Yes, I can. You can continue, please.
All right. Okay, once again, good morning. My name is Tawid today. Of course, I've joined the scene and I've listened to Abdulwasi look over. And I think he has actually provided a good foundation for this discussion. Of course, I'm not a lawyer. I'm actually a gender justice and child rights advocate and a freelance writer for the State Ministry of Women Affairs, project design and reporting.
Mr. Tawedi, your audio is not clear. Maybe you should remove your earpiece. We are using one.
Oh. Can you hear me clearly now? I hope so.
Yes, it's okay now.
Okay, good. So, all right. As explained, I don't see any need for me to actually delve much into digital rights or fundamental human rights as enshrined in the Nigerian Constitution again, because you have actually said a lot about that. But talking about digital rights in Nigeria, I'm very sure we will surely have a lot to say when we try to explain it based on the existing laws, based on what we have in the Nigerian Constitution 1999 as amended, and based on different legal framework that has come on afterward, and then the recent one, the National Assembly still working on. But digital rights refers to, of course, human and legal rights as related to digital media and technology. And I think in the UN resolution of 2016 actually extended that to the same rights we enjoy, talking about the political, the social, and what have you. But in Nigerian context, of course, we'll talk about digital rights. We'll talk about people having rights online. How many people know they do have this certain right? They can actually enjoy this kind of right online. How many people know this is the process for them to take if this kind of right is trampled upon? And aside from right being put upon by government, if we're talking about this if we're discussing this kind of issue, maybe in around 2001 or so, why internet was just coming up, and then we have Nigeria has over 200,000 people using internet. It would have been we are trying to be proactive to foresee issues, challenges that might arise from using internet. But this is 2022 with over 126 million people of the Nigerian population online. Over half of the Nigerian population are online today, and this has become part and parcel of our daily life. People using internet for businesses, people that they can't actually do without having their gadget to them. They're not actually being connected to online. So the more the people, the more we increase online, the more the more the tendency of having issues that has to do with discrimination, cyberbullying, and freedom of restriction. I'm talking about freedom of expression and the likes. So with this, of course, we have had different issues. We have had different issues related to digital rights. We have had different issues that could be cited talking about government trying to ensure that and as said by Abdul Wasil, rights are not absolute, of course. There are limitations to rights, but to talk about rights are not absolute. If the limitation to right are not because somebody thought or somebody's interest is being brought, or somebody's line is being crossed, that's the reason why there's the limitation to right. I think that one is out of discussion, but the limitation to right should be the Constitution says this. The Constitution says this. In as much as you go after this line, you have actually crossed a line as stated by the Constitution, not because somebody in power, not because a politician, not because a government thought that you should be restricted. And I think this is the issue we face every day online. This is the issue we face every day on internet. Freedom of expression and data privacy and what have you. And let me quickly relate this to. I know majority of us know a lot about this during the NSAS protest. I believe you can all hear me, right?
Yes.
Okay,
Yes, we can hear you.
All right. So I believe a majority of us can actually relate to this during the NSAS protest, and it was surprising how a teeming population of Nigerian youth were able to come up in more or less like revolutions, trying to revolt against the inequity of the Nigerian police force and then the killings all over the country. After this, or let me just say, what's wrap up this issue of NSAS protest was people's bank accounts being freaked, people being tracked, arrested, and the likes. This, you can agree with me that there must have been a breach of data privacy between bank, like I'm talking about financial institutions, and customers, because before a third party, let me say, government could access bank and have the right to freeze account. Somebody somewhere, like bank institution, must consent to that, even without the consent of those people that operate this account. These are different examples of data privacy being infringed upon. There are people that are journalists being tracked. They are being tracked and are arrested because Nigerian government do not want these people to express themselves. Nigerian government thought that is expressing themselves is more like, because there are majority of them actually that were actually brought before law courts on the charges of treason and felony. There are majority of them that are seen as threats to the national security. So all this issue, because of course Nigeria is facing the issue of insecurities, but most times all these are bringing all these to try people that at the end of the day, we find out that they have nothing to do with insecurity, or they have nothing to do with treason and felony, are what I just pretense to trample upon the rights of people, especially online. And let me quickly relate my own experience, personal experience on this, even before talking about where I work on. And I think that 2013 when I opened account with okay, let me not mention the name of the bank here. When I opened account, like fast forward to like 3 years after, I wanted to link my account. I mean, I wanted to have a NIN as directed by the Nigerian government, so everyone should have NIN and link into it their mobile number. I wanted to do that, and I went to NIMC center to try and register for NIN. After like 3 or 4 times trying to register this, later on, I discovered that my bank has actually sent my data, or the federal government has actually accessed my data through my bank, and then they have sent my data. And while registering this account in 2013, that was a mistake, perhaps from the bank, because I have been the date of birth has been my date of birth ever since. In primary school certificate I have, the secondary school certificate, both junior and then the secondary one has been the same thing. But there was an issue with year of birth, of which does not actually correlate with the year I'm using with mobile and telecommunication, this thing. So up to this moment, I'm unable to link my NIN, the one I was later given that has another date of birth, with the one, and whether MTN or whatever network provider has for them. And there is tendency what my line will be blocked. I may not be able to make call after this moment. Not because I do not want to link my line, not because I'm being defiant to this directive, but because there was a mistake from the bank. And then not even this, if my consent has been requested for before sending my data to this, perhaps I will have the right to access my data and try to correct, because I could remember there was the time I wanted to update my account. I put the correct date of birth there. Up to this moment, it's still the same thing. So let's leave that. Why would we talk about digital rights? Of course, why it is important, people accessing internet, people accessing social media. As somebody that work mostly online, try to ensure people have access to information, try to ensure, especially SRHR information, and like young people make informed decision. And someone that will try to ensure that gender-based violence is what we all rally around, is what we all roll up our lives and ensure we engage to end it. There was a time somebody related something to me that, of course, she, like, her right has been violated, like she has been abused when talk about harassment, sexual harassment on campus, but she couldn't talk about it. She couldn't speak up because of the fear of this condemnation online, the cyberbullying. People always talk down whatever, even if it is virtual, even if whatever you're trying to relate is virtual. She couldn't say anything online. And there are times that this same internet, this same digital space has helped in ensure that we get justice for victims of sexual and gender-based violence. So these things are like two sides of the coin and even edges. So it's actually important when talking about digital rights, because I believe nearly all SDGs depend on expanding access to information and communication technology infrastructure around the world. So we can continue to talk about digital rights. We can continue to talk about trying to bring governments back on their toes to respect digital rights. But it will be needless if we fail to focus on the clauses that our legal framework, our continuous legal framework that we continue to come up with, from the 1999 Constitution, as mentioned by Abdul Wasil, look about different acts, NITDA, different legal frameworks that tried or come up with different government coming up with different policies telling us they want to protect and data privacy or data protection or what have you. If most times until 2015, when we have a Violence Against Persons Prohibition Act, that we can know that is we have an
Hello, Mr. Tawid. Hello, are you there? So, hello. I think he's having problem. He's having issue with his network. So, I think I should continue till he come back. So, now I think having highlighted the legal framework that regulates fundamental human rights, so digital rights in Nigeria and international sphere, I think there is need for me to talk about, okay, let's say, what is violation of? Hello, can anybody hear me, please? Hello?
Yes, we can hear you. Yes.
Okay, I should continue, right?
Yes, please.
Okay. So now, violation simply means when there is a breach to this right, though, as I know, these rights in practical sense, they might, in real sense, they might be protected. There might be laws that regulate them, but as we know, they are our country, even if we have beautiful laws, enforceability of these laws are another thing. So, for example, let me try to relate. I think Tawid is back. Tawid.
yes, sorry,
Okay.
a network breakdown.
Okay, you can take it, please. Take it over.
All right, let me quickly round up this with this issue of Twitter and suspension of last year or so. And most times, like Twitter, especially in Nigeria, has been really helpful talking about freedom of expression, talking about a space whereby you go to and then you can easily access policymakers, you can easily speak to them and ensure that you influence policies in the interest of the Nigerian people. This has been a space whereby you can easily go to, as an entrepreneur and market your business, and of course, at the end of the day, you make profits. This is a space that, a youth population in Nigeria, you always have it, like you have more than half of youth population in Nigeria that will always be on Twitter almost every day having intellectual discussion on how to move Nigeria forward. But fast forward to this after the NSAS issue, just because Nigerian government thought young people are growing wings, and at the point they may not be easily curtailed if allowed to continue in this world, and perhaps might lead to that kind of revolutions they may not want. At the point, they decided the best way was to suspend Twitter. And meanwhile, this suspension did not only affect people, did not only affect anti-government people. This suspension bounced back on people that are not even concerned, that have little or less to do with whether you criticize government, whether you talk down on their policies, whether you talk down on their political system, or whether you talk down on the way Nigerian is being rule of law, respect for rule of law, or the democratic setting. There are ordinary people whose business, whose source of livelihood were affected just because the government somewhere thought of the best way to block or control their freedom of expression was to suspend Twitter. So that was that about Twitter. But I personally, I think it's, of course, most important when trying to talk about laws that will, digital rights and protection. We should focus on synergies between
So I think we lost him again. Okay, let me continue from where I stopped. So I was discussing section 39 of the Constitution, which
it's must
specifically talks about freedom of expression. Okay.
Hello.
Which specifically talk about freedom of expression, and section 39 sub 2. I am more interested in section 39 sub 2 here. We talk about that is every person shall be entitled to own, establish, and operate any medium for dissemination of information, ideas, and opinion. So this means that, let's say as a journalist, I have the right to establish or to own any media platform in Nigeria. And I think most of our traditional media houses now, they are now moving to online. In fact, Punch, they have websites. Mostly all of them, daily tours, they don't rely on the traditional means of disseminating information any longer. People are now accessing them through social media. But I think the Nigeria now is the basic problem we are facing in this regard is the issue of misinformation and disinformation. So the fact that you have right to express yourself, you should not try to misinform. The fact that you have the right to express yourself, the fact that you have the right to own and establish a media house, the fact that you have the constitutional right to own a media enterprise, the fact that you have the right to own an outlet, which is so aim also work is to sell information. If once you try to disinform or misinform the society, it is a violation to this constitutional right. So violation in a sense means a breach of a particular right granted by any legislation. So, for example, let me use what happened in my class as an example. I'm a law student. Despite the fact that I'm a journalist, I'm a law student. I think in December we have issue in my class. So, as we all know, traditionally, all in Nigeria tertiary institution, there is always be WhatsApp platform for classmates. So in my class, we have a WhatsApp platform in which everybody belongs. So my class rep just wake up one day and ignored this. Though two of my mates were fighting, they were abusing each other online. We tried to settle them. Then my class rep, with his own discretion, without consulting anybody, he locked up the WhatsApp platform. He locked it up. Okay, everybody thought this thing was fine. Okay, let's just make sure so that we have a serene atmosphere, so that everything will be buried. So first week, the guy failed to open it. Second week, he failed to open it. Third week, he failed to open it. Fourth week, almost 2 months, he failed to open the WhatsApp. Why? Then we approached him. Guy, what you are doing, you are overdoing these things, because what you are doing now is a violation to our freedom of expression. It's a violation to our freedom of expression, because you locking up the WhatsApp platform, you are denying us right to express ourselves on the WhatsApp platform. So we told him, but the guy was so stubborn until we related the matters to the appropriate authority. Then they asked him to open the WhatsApp platform. So what the guy did here it is an example of violation to freedom of expression as explained by section 39 of the Constitution. So I will still use another example that, I stated that another right that is protected online is freedom of association and assembly. So, and I used the example of WhatsApp when I was giving my during the first time I was speaking. So yes, I will still use the issue that happened. So I immediately, my course rep opened the WhatsApp platform. He removed everyone from that group. He removed everyone from that group. Then on his own Sokoto, on his own volition, he created a new WhatsApp platform. Then he added everyone back to the WhatsApp platform. So then everybody started questioning his decision. Then he was like, he has the right to do that. He has the right to do that. And as you know now, if you are so familiar to law students, law students, law student society, you know, we have what we call these judicial arms. Then this case, the student now took it up to judicial arm. They try to interpret the provision of the constitution that talk about freedom of assembly. And funny enough, the guy, even despite the fact that the guys know that the constitution empowers everybody to have freedom of assembly, that you have the right to either join the WhatsApp group or not, the guy is still trying to defend himself that he's the cause rep. So what the guy was doing was nothing but violation to digital for fundamental human rights online. So I have the right to associate with anybody online. I have the right to join any group I wish, not under duress or anything. I have the right to be with you if I want to be with you online. I have the right to express myself. So that is, I think Tawhid is online. I think I'm going to hand over the mic back to him so that we finish the session. Mr. Tawhid, please, can you proceed?
I'm really sorry. I believe you can hear me loud and clear now. My network has really been acting funny. Apologies once again. So I think what I was actually talking about earlier was, if I could remember, but okay. Now let me just round it off here by saying, I actually wanted to define digital rights before, but my explanation of digital rights, and then try to talk about it from violation of human rights from the government angle. And I think the definition should actually go like: digital rights refers to human and legal rights as related to digital media and technology and readiness to take responsibility. Why we try to clamor for digital rights, why we think digital rights should be what you should enjoy. You should have rights to expression, you should have freedom of association, you should have rights to data protection and the likes, and privacy. As said by Abdulwasi Olukov, I think we should as well be conscious of ensuring that enjoying our rights do not disturb others. Enjoying our rights do not trample upon the rights of others. Where your rights stop, other people's rights actually started. And we have had different experiences of people trying to say because they have this right, because they have that right. And at the end of the day, they fail to realize that is by trying to enjoy your rights, to a certain extent, you are actually trampling upon the other people's right. I'm saying this not because you are trampling upon somebody else's interest outside the constitution, constitutionally stated right or responsibility. Because when we are trying to say this, I'm trying to understand the inequality, societal inequality, or digital divide. We understand that some people will just wake up one day and because they have the power, they have the authority to do something, they have the authority to ensure that everybody is cut off from this system. Not actually because you trampled upon their right, but because they have the power, or because they think they exercise right over you and you cannot dare cross their line. The same was the issue of Twitter suspension, different arrests, different surveillance, tracking of journalists, tracking of influential young people, like people that actually have voice and have laudable voice that would echo the interest of the youth. But because those people in government thought that the best way was to ensure that they render them voiceless. And the only way to do that is to ensure this global village, this place where we gather ourselves, this place where we discuss and understand the way forward, know where we are, and know what's next to do in ensuring that we create a society of our own, is what is cut off, like is brought down. And the clamp down on this internet, of course, there are some depth majority of deviant young people that are actually like that are not stoic. You know, the problem of Nigeria is what is how easily we become stoic in the face of repression. You know, during this kind of clampdown, during kind of right violation, it has become like Nigeria are accustomed to finding their ways. Like Nigeria are accustomed to finding their ways to ensure that they still keep their eyes above the water of this. But like there are Nigerians that will always tell you, it is parts of Nigeria that okay, stoicism. They will accept what comes to them as though there's never anything like constitution, there's never anything like rule of law, there's never ever anything like fundamental human right. So we live in a country whereby we find it easy not to speak against oppression just because perhaps on a religious line, politics, or ethnic. So it is very important to ensure that we focus on having a law that is devoid of clause. That clause of giving the states the right again to domesticate the law that has already been assented to by the president, passed by the National Assembly and assented to by the president before it could be effective. The same thing happened with Child Right Act, why I was talking about earlier. Child Right Act was passed and assented to in the year 2003 in Nigeria. As well to this is 2022. Of course, there are 6 states in Nigeria that are yet to pass this bill, yet to domesticate this bill. There are states that have just domesticated Child Right Act in 2021, almost 20 years after this right has been passed. So just imagine what has been happening, what could be happening to children of, people like children of all these states that were not enjoying the same right as though supposed to enjoy it, because there is a legal framework that's supposed to protect them. And it's not even all about passing, it's not even all about domestication alone. There are states that whenever they decide to pass this bill, whenever they decide to domesticate bill, they will still sit around it and try to ensure the fit has some essential provisions. They try to ensure that they check some provisions and ensure it do not speak against perhaps their religious understanding, societal context, considering societal context. And in most situations, the societal context in consideration for passage of this bill might actually defeat the essence to which this legal framework come up. Let me make this as an example. This issue of Child Right Act again. The essence of this is to protect children. It means to protect every child's right, like gets right to education, ensure that is and get children not being hands off in marriage as earlier as in 13, 14 years. You understand? But in some states, especially in the north, where these acts are domesticated, the state assembly still sit around, still review this law and ensure there are some provisions of that act that were removed, just to ensure it suits the taste of their own religious undertone to which the Child Right has lingered up to 2021. So the same thing, I think it will be important while trying to ensure we have an holistic legal framework that will affect everyone, that will not discriminate whether you are poor, whether you are rich, whether you are middle, whether you are female, whether you are from this class or not. I'll ask anything to do with social structure or on gender line, is to ensure we cut off the clause that gives the state's rights to still review laws that has already been passed and accepted to. So I think this will ensure that we have laws, explicit law that will affect everyone from hub to from Abuja, like the federal capital territory, to somebody in the far-reach village in the north, from somebody in the north, I mean Sokoto, somebody in the far-reach village in Borno State or Abia or any other state across Nigeria. That's about that. Well, I mean, and hello.
Hello, Mr. Toy, you can hear you, please.
All right, so you can take it up from there. I might have to continue later.
Okay, thank you, Mr. Toy. But before you go, I want to ask you a question. So, as a gender-based violence advocate, you talk about the VAP, that is Violence Against Person Prohibition Act. I want to ask if you can shed more light on how the enactment of this act has helped you in your field of work, like has helped you in advocating for gender-based violence online. So can you just take 2 to 3 minutes to explain this?
All right. I think this is very simple. Like, I think I will have to just cite example, and I think this is very viable. It's something I can easily go online and check. Now, before the VAP, like Violence Against Persons Prohibition at 2015 become into existence, like become an act in Nigeria, we know how people come up to actually speak up when it's come to relating their experience as survivors of SGBV. Like with this law, with this explicit law that actually tackle SGBV in place, we have been able to repose trust in the judicial system, and people having trust that they can actually seek redress. They can actually seek a remedy in the law court and get justice. You know, like the delay in justice dispensation most times, I mean, when it's come to the issue of sexual and gender-based violence, is the disparities between one legal framework that supposedly should front holistically against STBV and another. Take, for example, the Nigerian Constitution 1999 has amended as provisions that penal code that is, applicable only in the north are, against. Let me say that. You know, when we talk about rape, let me use that as an example. Rape, penal code do not accept that this. As Nigeria, as Constitution pegged age of marriage to 18 and believe any sex with any girl under the age of 18 where non-consensual sex is what is rape. Penal code believe marriage can happen, like marriage should go on if at all it is what, in as much as the girl is as old as 14 years. There's a difference between these. There's a difference in this profession compared to criminal code. All these discrepancies are what VAPP corrected. And aside from this, there has been increase in people's understanding. There's been improvement in people's understanding that, okay, seeking remedy in the law court alone is not alone in the profession or in our effort to ensure we fight against gender-based violence. You are entitled to be compensated and ensure you get justice freely, have access to medical care and psychological care as well in this law. So it has really helped to ensure that we get more people speaking up, to ensure that we get more people understanding that they have a right. They do not have to they do not have to keep me. They do not have to just recall back to their share because society believes it is out of law for a woman to speak up that she has been raped, that okay, women actually deserve to be raped because of what you wear, where you belong, time you go out, or no. All these things have been addressed and people now have the trust in the system, and there's been improvement in the delay in justice dispensation because we have a law that actually have clear explanation of what this offense is and what should be the punishment for this offense, as against try to just oppose different law that might be ambiguous, that might actually be responsible or be a factor for the delay in justice dispensation before the DPP had come on board.
Okay, thank you, Mr. Tawid. So I think I was speaking on how free are Nigerians in expressing their digital right online, and I was using the stories that happened in my own class as examples. So I stated, so the first thing that affects Nigeria, that affect Nigerians from enjoying their fundamental human rights online. The first thing is the first problem is lack of awareness. Even those people you think that are aware are not aware. So imagine if things like this happen within law student society, and even when we reached the authorities, they failed to provide the needed solution. So even one of our lecturers was even saying, it is a course rape. He has the right to do that. All these fundamental human rights you are talking about, and we don't think it is applicable online. So the first problem is lack of awareness. People are not aware. People are not informed. People are not informed that the same right you have, the same right to life you have online or offline, the same right to life you have online, the same right to associate with anyone offline, the same right to associate with anyone online. So the same right to express myself while standing before you as my lecturer is the same right I have as a student to express my opinion within the ambit of law in our WhatsApp group that is being closed by my course. So the first problem is lack of awareness. And I think the second thing that is affecting enforceability of fundamental human rights online in Nigeria is the Nigeria system itself. Nigeria is too bureaucratic in nature. Let me give you an instance. I told you I'm also a journalist. So there was a time I was investigating a mining title of a particular company. So the company, when I spoke with the company, they let me know that they have a mining title, but from our interactions, I realized they were self-contradictory. Because why are you telling me you have a mining title? So what I mean by mining title, for those who don't know, is mining title is a license given to mining company to drill and mine mineral resources in a particular geographical location in Nigeria. And this mining title is basically being regulated by Nigeria Mining Act 27. So, and the institution that is empowered to give this title is Nigeria Cadastral Mining Office. So when I asked them, they told me they have mining title, and they still went ahead to tell me that they have issue with federal government. So, and I felt like, how do you have mining title and federal government will still be chasing after you? So, and I realized this is a red flag. Then I investigated them. I realized their mining title has expired since 2020. I check it online. I check it through the portal of Federal Ministry of Mine and State Development. So then, to have human resources to back up my findings, I went ahead to cadastral office. I told them my findings. So I told them I need access to this information. This is what I have found from my own personal investigation. Please, I need you here. I want you to do this. I want you to do this. I told them what I want. So, but to my surprise, they told me that, see, for you to have access to this information, you have to pay 75,000. How about, just see, can you see, as in, the Constitution said, I have freedom to access information. Fundamental FOI, that is Freedom of Information Act, stated that I have right to access information. So, and to the best of my knowledge, I demanded this information within the ambit of the law. I told them I'm a journalist. I told them why I need it. I confessed them, but they told me, even as a journalist, I need to pay 75,000. So just imagine if I need to pay that ridiculous amount of money just to enjoy my freedom of association, my fundamental human rights. So just imagine if that thing can happen even offline. What do you think will happen online? So, in fact, this issue of freedom of information, freedom of access to information is the system of Nigeria is undermine the access to information online. Because let me give another relatable experience. When there was a time I need access to, as a law student, I was working on a research, and I want to access a particular state laws here in Kwara State, my state, my my state of origin. So I try to access, I check online, I realize our state of assembly they have website, though the website is not updated. It's not updated. Then I check if I could get any document online. To my surprise, even the plenary session, everything as regard to legislative arm, is not uploaded. These informations are not uploaded on this site. So our system is designed to deny this right online. So it's not only right to expression, it's not only right to associate online, even right to access information is also denied. It's also denied. It's always denied online in Nigeria. So I think now I will briefly talk about, before Mr. Timothy Tion join us, because he told me he will join us soon because he's busy in courts. He's having a matter before the court, so he will join us maybe in the next 5 to 10 minutes. So before he comes on board, I will talk about, assuming there is a violation to my rights online. Where should I go to seek redress? Where should I go to seek redress? So, like every other traditional fundamental human right, once you perceived that your right has been tampered upon online, there are places in which you need to approach to enforce your fundamental human rights, whether online or offline. So the first institution you need to approach is Federal High Court. Federal High Court is empowered to listen to cases that relate to violation of fundamental human rights, and also state high courts. State high court also is empowered to do that. And aside the conventional courts, we have national human rights commissions, we have the public complete commission, and we have judicial commission of inquiry. So I know you might ask, what is the advantage of the first two, Federal High Court and High Court of a state? They are constitutionally empowered, because Constitution clearly stated that you can approach any high court in a state in which your right is being infringed. Any high court. So any high court here, the phrase any high court is on the line. So it means you can approach either Federal High Court or State High Court. So you might ask, why do I need to approach high courts? Why do I need to approach conventional courts? Or why do I need to approach these commissions? There are advantages and disadvantages. So if you approach high court, if I approach either of the high court, whether Federal High Court or State High Court, the advantage is that if I approach them, the decision of the court will have legal responsibility, and there will be element of sanction. It can be, the decision of the court can be enforced. Because there is what we call contempt. For example, if the court pronounces a judgment and you fail to abide by the judgment of the court, you can be held for contempt. And punishment for contempt is dependent on discretion of the court. So the advantage is that if you approach high court, any of the high courts, and fortunately enough, the court pronounce in your favor, the court give judgments or rulings in your favor, the judgment the judgment will be stand and could be enforced against the person. So, but the disadvantage that attracts or that goes in with approaching high court or either Federal High Court or State High Court is that we know that our judicial system is so corrupt that even you will be surprised how the case might be turned around. So you should know that once you are approaching high courts, there are things you are going to encounter. The first thing is delay in giving judgment. I have witnessed a case that started in I've read a case rather that started in 1985, and it is until 1985 till 2018 that they later give final judgment on that. Just imagine the case spending more than 2 or 3 decades. Even you being a litigant, you get fed up and you get discouraged. You get demoralized in pursuing that kind of case. So that is for conventional courts. What of the commissions like National Human Rights Commissions, Public Complete Commission, and Judicial Commission of Inquiry? So if you approach these commissions, the advantage is that the the proceedings will be fast-tracked and there will not be delay. There won't be delay. But the disadvantage is that if you approach them, definitely they can only pronounce, but to enforce might be difficult. To enforce might be difficult because they are not conventional courts. They are just like a special court of inquiry. So even if they give decision, the decision might not be solid and strong like that of conventional court. So then having said that, I think there's need for us to talk about remedies available where violation of human rights occurs. So now let's say my right has been infringed upon, someone has denied me the right to access my phone, to access my Facebook account. Someone has denied me the right to tweet on Twitter. So what are the remedies available for me? When I say remedies means like things to compensate me with. So we have like, okay, in this regard, I will make reference to order Article 11 of Fundamental Rights Enforcement Procedures of 2009. This article stated that at the end of any application under this rule, court may decide if any act of fundamental right provided in the Constitution or African Charter make such order, issue such writs, and give such direction as it may consider just or appropriate for the purpose of enforcing or securing the enforcement to which the applicant may be entitled to. So what this statement is saying is that it is the court, though it is the court that we determine the appropriate order, the appropriate writ is going to give where it is being established that there is a violation as to rights, fundamental human rights as enshrined in the Constitution or as protected by any charter, whether African Human Rights Charter or the UDHR. So, but some of these order may include award of damages. What I mean by damages means compensatory relief. So, as stated in the case of Senate Bank that I mentioned earlier, so when the client realized that what Senate Bank is doing persistently is violation to his right to privacy, then he approached the court, the Ogun State High Court, and the Ogun State High Court pronounced that so what the Senate Bank has done is a violation of fundamental human rights, and they pronounced or they awarded 5,000 naira against Senate Bank. So also we have the issue of injunction. What is injunction? Injunction is like an order of the court. For example, let's say someone sees my phone, or someone hack my Facebook account, and I know the person. So before I will even ask for a award of damages, the first thing I need is the injunction of the court. The injunction of the court means like an order of the court to stop or enforce someone to stop someone from doing something, or to compel someone to do something he doesn't want to do. Like, let's say Mr. Hay hacked my account. He hacked my bank account. So, and I know the person that hacked my bank account, and I have studied a case of violation of right to private, violation of protection of data, and right to violation of right to privacy. So, the first order that I need to seek before the court is order of injunction for the court to compel him to release my account. So that is injunction. And also we have the issue of mandamus. What is mandamus? Mandamus is also an order of the court to compel a public officer to do something that is bound to do. If he's failing to do it, this order of mandamus, it's usually been issued by high courts to compel any public officer. For example, let's say like NITDA. I told you that their right, their duty is to protect data privacy in Nigeria. So let's say these people, they are now being negligent in discharging their duty. They have been negligent in discharging their duty, and their negligence has caused damage to my personality, or it has made me to lose my data. and it's maybe this was as a sort of their negligence. So I can approach the courts to seek for order of mandamus to compel them to do what they fail to do. So that's it. So Mr. Tawid.
Hello, Mr. Abdul Wasiu.
Ma?
So, thank you very much. It's been a very interesting one. Our digital rights cannot be we can't say we can talk about our digital rights too much of it, because the world is going global and everything is going online. And so our digital rights is very important. So thank you very much for a very interesting session. I'm sorry to say we are running out of time. We'll just quickly go to the Q&A session. If anyone has a question for Mr. Tawhid and Mr. Abdul Wasiu, please, you can raise your hand or type in your question in the chat box. Thank you. Please, any question for, anyways, you can also drop your question on the Wova app. Our panelists are always available to answer your questions. So thank you very much to our panelists from Usmanu Danfodiyo University, Sokoto, Nigeria. It was a very, very insightful and very interesting topic. Thank you very much. Hello, Mr. Toib. I was just notified that you could go on for a few minutes, so you can still have the floor.
All right, thank you so much, Ma. Can you hear me? Hello? Okay.
Yes.
All right, I just want to round up this way, while I was talking, you talk about rights, data professional and protection and all the issues that will continue to experience online as an internet users and as Nigerians, and considering the political situation, and especially how the digital ecosystem is becoming a lucrative space for the Nigerian government. At this moment, I think it would be important for many people, like for majority of the Nigerians, to be aware, okay, that they have a right that has to do with online. Because if you go out, and I think this is the reason why this kind of discussion, this kind of conversation is important, to actually understand there's this right for you. There's this provision in the constitution that states that you have a right to be protected. You have you have a right for your data to be protected. Because if we take a look at how people access internet these days, are people that actually approach all those internet and money lending firms, and at the end of the day, because perhaps they fail to pay, at the end of the day, just what you see, like cyberbullying, sending messages to spamming other people's and inbox because somebody has actually approached you to pay money and defaulted in paying back the money. So we should, this because majority of us we just approach them, and when they send privacy, term of and conditions to you, privacy and the likes to you, majority of us, not all of us will take time to read anything that has to do with whether you consent to your data being shared across to anywhere, whether you consent to your data being shared with anyone. If you fail to do this, you fail to do that, or if you default on this promise or the likes, majority of us will just click okay and then we'll go on. So I think it's important for a good population of Nigeria to be aware they have a right, and that's important. That's why it is important to do awareness creation and ensure people, not everybody that are online are actually aware about this. And another thing is internet access. You know, before I was talking about, I said nearly all UN SDG actually depend on access to information and communication technology infrastructure around the planet. So it's important that we try to address the global inequality when it comes to accessing the internet. And as a gender justice advocate, and I'm very sure you and I are aware of this, that is, women like generally have less access to the internet. So we know why we try to talk about our rights, enjoying our rights online, and try to ensure we talk to ourselves of our responsibility, our readiness to take responsibility, while also enjoying our rights online, and our readiness to ensure we do not trample upon the right of others. We should also focus on ensuring other people as well who have no access to the internet have access to the internet, because this is where the world has moved to now. This is the means of which people express themselves. This is the means of which people communicate. This is the means of which people assemble, and then they form, and like they become informed, and then they can make informed decisions based on the kind of assembly, based on the kind of people they meet, based on the kind of interactions they hold online. So it is important to do awareness creation and to continue this awareness creation and ensure that this will take it to places that actually matters. So thank you very much, and then we ensure that this law, this cybercrime law, the existing law, the new law that will explicitly ensure that digital rights and data protection. I mean, Nigeria's data are protected, and then we have our digital rights protected. Do not have any clause that will give states the right to tamper with the content or the provision of this law, as to be able to stop them from trying to filter those laws, and then trying to defeat the essence of those laws based on the whims and caprices of those political or those politicians, or perhaps the social or religious contents in different places in Nigeria. So thank you very much. Thank you for having me.
Thank you very much. I'm very glad you mentioned awareness, because to some of us, the internet and the digital space is not new, but to most people, the internet as a whole is a new environment. So people tend to be naive and scared sometimes. Like you mentioned, people who call these loaning app, they just call you up, and you've had people running helter-skelter because they've called them that a friend of theirs collected loan and stuffs like that. So yes, I'm glad you mentioned awareness. So how do you think, my question is, how do you think we could create more awareness, both as a private citizens, as NGOs, CSOs, stakeholders, and even the government?
Okay. All right.
Mr. Tawid, can I chip in something?
Okay, I think if that's important, before I answer the question.
What do you say?
I mean, if that's very important, before I answer the question, you can.
Okay. Oh yes, I also want to contribute to the question. So, yes, I think on this, the first thing that we need to do is we should make sure eventually we get the bill enacted. I mean, data. I think it's data protection bill that has been legal at the National Assembly for years. So I think there's need for us to for the lawmakers to be more serious about this, because even as we are speaking, we are expressing a lot of violation to digital rights every day. So, and we can't shy away from the reality. We are moving, we are evolving, we are moving from the manual life to digital life. Everybody is seeing what is happening on Twitter. Everybody is seeing what is happening on social media every day. So in fact, even our political life is now being moved to online, not like the traditional means before. So I think the first thing we need to do is we have to enact the law. So after we enact the law, then I think the awareness will start. So how can we do it? How can we? I think the best way we can go with the awareness is we should try to use a means that will reach the people at the grassroots. The people at the grassroots, they are the most concerned in this regard, because like the issue of Child Right Act, to some extent, we have recorded a lot of sources in as regard to its awareness. I think if we can use the same method, most of NGOs, most of stakeholders use in championing the domestication and increment in the awareness of Child Right Act and VAP, I think we can use the same thing for the bill. For the bill, yes, it will go a long way. And also, like the issue of intellectual property rights and intellectual property law. Now, I think almost all schools, that is offering, all schools that are offering law, degree, they have put into their curriculum intellectual property law. If the same thing can be done for digital rights, there is need for them to separate digital rights to make it a separate course. So, it is through these universities that we are building, or we are breeding new lawmakers. We are building those who are advocates of law. So, if not that, I personally have been trained on digital right by Paradigm Initiative. So whenever I'm talking about digital rights in my class, it will be like maybe I'm speaking new English or I'm speaking new language. Most of them doesn't know, and I used to tell them that it's not that it's a new thing. It's something that has been with us for years, but it's just that we are trying to conceptualize it now. So if those who are concerned at the educational space can see the need for them to introduce it as a course, the way they did it for intellectual property, the way they did it for international law, international humanitarian law, the way they did it for most of the banking law. So if they can do it for digital right law, even if it is elective, that alone will go a long way to promote the enforceability and advocacy in digital rights.
All right, thank you very much. Let me quickly answer a question. So thank you so much for the question. And let me start this way. I think Nigeria as a country is a country running on the opinion of majority, regardless of the firm decision of the majority. And this is actually, has actually formed the ridiculous basis of which we have become stoic as a people. So, and talking about this thing is basically because of frustration, economic frustration, and in this issue of a loan app and trying to send unwanted message to different people because somebody defaulted, somebody failed to pay his or her loan, is of course because of the current and economic problem we face in the country, and the people that will surely caught in the web of this approaching all this loan web are what? Young people. Majority of them are young people. So to do this, to create awareness, to ensure that this will stop this, aside from having an enforceable law, effective law that will ensure that this loan company, this internet loan company, are brought to book whenever there is a breach of contract in exposing or in data privacy or data protection. We should ensure that we have an inclusive awareness creation. Inclusive awareness creation in the sense of we should ensure that we have young people championing the cause of addressing this issue. Because I have majority of young people like my peers, my mates, people that you always find them online 24/7. Majority of people that will contributions online that contribute to no little or nothing about anything like digital rights or digital law. That's not because they are not educated, that's not because they are not intelligent, but it's just because they are not aware, they are not informed, and there is need for more and awareness to be created. So we should ensure that it will focus on young people championing this cause. And how can young people champion this cause? By ensuring that we have an inclusive environment for awareness creation. And aside this, why we have more young people as champions of digital rights and data protections and having to address all this shaming, all those excesses, trying to curtail the excesses of this long app. We should focus on and let leverage on the importance of our traditional media as well, especially the radio aspect of it, trying to ensure that is where we have a wider range of audience listening in different language of which they can understand, in different language of which our message can go a long way to understand their rights when it's come to accessing social media. You know that at times that you pass message on social media, we most times have different target audience. And most times it's not all the times our message can reach a wider range of audience compared to using traditional media. Despite the fact that is what we have all come, majority of us have all come online, and majority of us are living our life, a new life, a different life on the internet. So we should try and leverage on that. Even those that are on the internet but may not see the message, may not see the advocacy, may not see the reason why they should be aware of their digital rights, will surely listen to it while we leverage on that. And then we have more young people championing the process. We surely have an headway. And then we have government sanctioning, like as interpreted, or as provided by law, sanctioning law, don't have that actually trespass, don't have that actually go beyond their limits. So we should have a particular law that will checkmate their actions and inactions to ensure that we have a well-protected digital right and privacy in Nigeria. Thank you.
Thank you very much. That was a very good answer. And I'm glad you mentioned radio, because everyone who knows me knows I'm a radio person. Modern, but I love my radio. I listen, I get most of my information from the radio. So I think, radio can be a very means to get to, like your colleague mentioned, to the people in the grassroots. Idris Muhammad, your hand has been up, so you can unmute and ask your question. Idris Muhammad. I think he left the call, but there's a question in the Q&A section. It says, has the Digital Rights and Freedom Bill been passed? Someone is asking. Okay, Idris doesn't have access to his mic. Can you please type in your question? You can type in your question in the chat box.
Hello.
Okay.
Hello, everyone. Okay, thank you very much once again for the wonderful presentations. So my question is almost similar with Amina. That is why I was busy saying I raised my hand, because I had Amina trying to ask the same question I wanted to ask. My own is because I have been in the field mostly engaging with women on this issue of digital inclusion. And what I realized that the awareness is not even on the issue of the digital right and inclusion. The awareness, I think, should be channeled even on how to use the digital tools available, both the social media and other internet facilities available, because majority of the people, especially in the North, I made mention of North anytime I'm discussing about digital, because I came from the terrain. I have full knowledge of what is happening there in concerning digital space. People are ignorantly and carelessly releasing important data. That is why they lost issue of privacy, and they always expose themselves into the issue of fraud and other internet scamming activities. Just, I think, last few months, there were messages coming to people via their WhatsApp platforms, asking them to fill particular form for a fill form from the federal government. And these kind of issues are the major ways people are sharing their data ignorantly. I think my mom was one of the victims, because I got back home and she told me that they sent her a message, and she called one of my younger brother, and he filled everything about her, including her BVN, her date of birth, and some details concerning her ATMs. I was so angry, but later I realized that yes, it was ignorance, and lack of awareness that caused this thing. If being people are fully aware on how to even use the social media platform, I think such kind incidents should not even occur, take less of people exposing their data online. So I think the awareness should start even from educating people on how to use the social media. I was so glad last year I was in Kano. I attended a program by CITAT. CITAT is one of the organizations that also engage in grassroots campaign on digital issues. So I was so happy when I saw how they engage women on how to use Facebook, social media, and report issues of domestic violence in their various communities. So I think for us also, we can start with educating people, especially in the northern part, on how to even use the social media platforms as well as the other internet tools available. Then we can go ahead with issue of digital rights, data protection, and some others. Because if you haven't teach them that whenever you're talking about digital space, they will find it something very strange. They'll be asking you, do we even have right on digital space? Take less of litigation and some other issues. So thank you very much. Idris from Sokoto.
Thank you very much, Idris. I remember we had this discussion recently with you, and I can testify that you're very passionate about digital inclusion. Thank you very much for the contribution. I see your last panelist is here, Mr. Timothy. Would you like to say something?
Okay, I want to make some few comments. Sorry, I came. Can you hear me?
Yes, we can hear you.
Okay, sorry, I came in late. I was a bit busy. Sorry about that. Okay.
No problem. Your colleagues had us well engaged.
Okay, so I just saw on Twitter Paradigm Initiatives 102 that they were asking how free are Nigerians to express their digital rights online. So I want to just comment on that statement a little. Well, Nigerians are free and not free because there are certain laws that are still limiting, for instance, freedom of expression, like the popular or notorious Section 24 of the Cybercrimes Act, which makes it an offense to even insult somebody, and to say anything that harms, in summary, to say anything that harms somebody's reputation. That particular section has been used to arrest persons and detain them severally, and I understand there is a lawsuit challenging the constitutionality of that section. First, it was at the Federal High Court, and the Federal High Court upheld the section that's valid. It went to the Court of Appeal. The Court of Appeal still upheld and some other civil society organizations. And also, that particular section has been a subject of litigation at the ECOWAS Court of Justice. And fortunately for civil rights organizations, the ECOWAS Court of Justice found the section to be violative of freedom of expression, violative of Nigeria's constitution and the African Charter on Human Rights. And it ordered that the Nigerian government should amend the section because it violates the freedom of expression of Nigerians. But unfortunately, up to now, the Nigerian government has not complied with that judgment of the ECOWAS court. So, as it sounds, yes, Nigerians, with respect to freedom of expression, Nigerians are not so free to express their sentiments or to express themselves online because of this section 24. And apart from section 24, there are other provisions in the penal code law and in the criminal code law dealing with criminal defamation. That's saying something against somebody that defames the person is a crime, but it's under international law, it's criminal defamation is being discouraged. That if you harm somebody's reputation, the best the person should do should be to sue you in a civil court and civilly. The responsibility of the state, because a crime is considered to be not just a crime against an individual, but the state. So reputation shouldn't be a crime that the state will have a stake to. The state should not have a stake in protecting somebody's reputation. So criminal defamation should be decriminalized. It should no longer be a crime. Because most times what happens is that it's mostly government officials who or public servants or top high ranking politicians who use this law to like stifle dissent or clamp down on people who want to express their opinions and hold government to account. So the law as it is serving no useful purpose. It's rather deterring Nigerians from expressing themselves and holding the government accountable. And democracy involves people holding the government accountable. Transparency. When you ask questions, that is when the government will be transparent and be accountable. But if top politicians or government functionaries are using this criminal defamation to clamp on people's rights to hold government to account, then the law is counter democracy, it's anti-democracy. And that is why the ECOWAS court has found that section 24 is unconstitutional. So I'm calling on NGOs and other civil society organizations. Apart from section 24, we also have the penal code. I can't remember the sections now, but there are certain sections in the penal code which somebody that doesn't want you, somebody can use to stifle your expression, like criminal defamation. And then there's even laws who say you should not insult the head of state or the government under the penal code and under the criminal code. Those laws were made, those laws were handed down by our colonial masters, and when they didn't want any objection or with any counter to their rule, when they were ruled, any counter to colonial rule. But we are now in a democracy, so such laws should be no longer be in our statute book. So apart from section 24, civil society organizations should also file suits challenging those other laws in the penal code and the criminal code, which can be used to stifle freedom of expression. That is just the few. Well, and then recently, I think a few days ago, concerning privacy and data protection, I was reading that a court in Ogun State has fined Zenith Bank for sending spam mails or unsolicited mails that constitutes a breach of the right to privacy, constitutional right to privacy. And that is a commendable decision. And as the other speakers were saying, we need to really do more in data protection in Nigeria. We need to have a comprehensive data protection law, and not just the NDPR or Nigeria Data Protection Regulation. Yes, the regulation is a step in the right direction, but we have to do more than that. The international best practice is to have a law and then create a commission, which a data commissioner or head that will be in charge of that commission, and the head should be independent or autonomous of the government. But what you have now is not really the international best practices. So we should try, the relevant stakeholders should try and ensure that a comprehensive data protection law is enacted in Nigeria. So far, Paradigm Initiative and other civil society organizations and stakeholders have been doing well, but there's room for improvement. We can still do more. Thank you.
Thank you very much, Mr. Timothy. I believe we're getting there, and baby steps, I believe. So any last, okay, there's a question in the chat box, and it says, has the Digital Rights and Freedom Bill been passed? Someone would like to know. Any of you could?
To the best of my knowledge, it has not been passed. I think there was a time, if I remember, well, there was a time the House, the Senate passed it, but the president refused to sign it. So I think it was sent back to the Senate for them to, I think, do one or two things that is the presidency asked that it should be done. So that is the best I know it helped, but it has not been enacted. It has not been enacted into law.
Okay, thank you very much. Abdul Wasir, you mentioned Zenith Bank being sued. How can I sue Airtel? They've been disturbing me with unsolicited calls.
Okay, you want to sue Airtel?
I want to sue them.
So that's, if you think you have a good course of action and you are ready to pay lawyers, so that one will be.
You,
So
you
because
can't just do, you are
there is
not
no,
coming lawyer. You can do pro bono for me.
I know I'm paying for school fees now.
Okay.
Okay. You can
Okay, you
also
introduce me to a friend then that will do me pro bono.
No, I don't have friends that do pro bono. Most of them won't do it.
Really?
Yeah,
yes. Okay.
if you
Let
want to
me
do pro bono, it will be for not for someone like you, man.
Okay, maybe Mr. Timothy will help me.
let me. Okay, no problem. Let me chip in a little. Apart from suing, yes, you can make a report against them at the federal. I think the Federal Competition and Consumer Protection Bureau, if I get that right. But they have been very active in recent time in ensuring that consumer rights are protected. Take their head, the DG Tunde Erukera or so, I can't remember his name, was Babatunde somebody. He's very active on social media and they are very willing to take up such cases, apart from going to court, because sometimes court can be very expensive, you know. Although there are some few lawyers that can do them, such cases pro bono, and then perhaps if you get damages, they can get their fee from there, but such lawyers are not many. So sometimes you can also explore the option of making a complaint against any errant body organization to the Federal Competitions and Consumer Protection Commission. Thank you.
Thank you very much. So I would like to get some parting words from each one of you. Just 2 minutes each. Thank you.
Miss Amina, before that, I want to ask Mr. Timothy a question, please.
Okay.
Yes, sir. I want you to. I've been having difficulties in understanding the main essence of the Credit Reporting Act 2017. The Credit Reporting Act 2017. So, is there any correlation between this and Nigeria Communication Commission regulation that was enacted in 2011?
Okay. The Credit Reporting Act, sorry, I'm not taking my time to go through that, but what I understand is that, okay, for instance, when you take, I heard people talking about loan apps. When you take there are some loan apps, because I've taken some loans too, so I know if you sign up to take a loan, they will ask whether they should report, whether you want a rating to be given to the Credit Reporting Act. So by and large, what I think that act stands for, because to be frank, I've not adverted my mind, I've not run through the ad, but read through the ad, but what it says is that if you are taking credits from credit or lending organizations, over time we should be making reports about people that are taking credit to that credit. There's an agency. So if you're they keep records. So if you're a bad debtor or something, it will determine whether a loan agency should give you loan or not. So in essence, that is what the Credit Reporting Act is all about. So I don't think there's any correlation between that act and the other one you mentioned. I think the Nigerian Communications Commission Act or something like that. That's the best answer that I can give.
All right, thank you, sir.
Okay, parting words.
Okay. May I start that, please?
Yes, you can.
All right. So thank you very much. And to round it off, I think, and I want to suggest that this is me just thinking like the best way, because I think going to court for digital right issues and breach of data protection issues, more or less like compounding issues in court, and then providing ways of which cases lingers in court 3 to 4 years. Why not try and advocate for a special court that will, because you and I know that the digital space is our new life has to do with everyone of us. Majority of us every day, always with our phone, always with our gadget, and want to know what's happening online, and then we even live a different life online. So why not a special court, just like talking about the family courts and the issue of sexual and gender-based violence? So that's one. And I think why we focus on digital awareness creation on digital rights, and then ensuring that this will let everyone understand the reason why they should take responsibility of their actions and inactions when it's come to digital rights. I also think commitment to protect the people's right to access data and information and to disseminate this without fear of course, fall under the purview of government. And so I think government also needs to ensure transparency in decision-making processes, and as well create an enabling environment for civic participation in the governance of this, the digital of the data and then as well digital space. So that's my conclusion. So thank you very much for having me. It's an honor to be here. Thank you.
Thank you very much for being here. Abdul Wasiu.
All right. So for me, I think from all what we have been saying since yesterday till now, I think everybody have understood that digital rights are not privilege. They are rights like every other right. So if they are right in which they are inalienable, something that it's something you must enjoy for by virtue of being a human being. So I think the Paradigm Initiative have been doing well because I've been attending most of Paradigm Initiative programs. So I think, as stated by Mr. Timothy, there's still need for improvement, especially by targeting people at the grassroots. You guys should try to shift beyond targeting the elites. Sorry to use that word, but people at the grassroots. I live in the north as well. I school in the north. I know sometimes even if you are dealing with these people, and they are mostly they decide most of things in Nigeria. Like our votings, they are the one that they will vote a lot. People, you and I, we might not even vote. They will want to vote. So with all these things is necessary for them. So thank you for having me, and thank you, Paradigm Initiative.
You're welcome. Thank you, Mr. Timothy. Anything from you?
Okay. Yes. Okay, I'll just make some few comments. Like the other panelists said about what creating special courts for data protection. Well, that would be good, but I think it's bureaucracy and more. I think other than in Lagos State, they have special offenses courts. So even in the current system, you don't necessarily need to create a fresh or a new court. You can just say, okay, some judges should be handling these cases within the high court or whatever division. Some judges, they should only be handling these cases and they should undergo training, because sometimes some of these judges, not all, but some of them don't really even understand this digital rights and all that. So they give decisions that are quite funny. So judges should be trained and retrained, and then they assign, those cases should be specifically assigned to them. And then apart from that, if we had a comprehensive data protection law, we will have the Data Protection Commission, which can handle some of these data rights violations before it gets to the court, because like we all know, court system sometimes is expensive, but if it's the commission handling it, will be less expensive. And then on the area of enlightenment, yes, it's good, like Abdul Wasil said, you should take this down to the grassroots, because at the end of the day, they're the ones that they are the majority. Not everybody is on Twitter or on social media. So radio jingles and rallies, town hall meetings will be very nice in educating people at the graduate about digital rights. Thank you.
Thank you very much. What an interesting session. I trust everyone here has a broader idea about their digital rights, their freedom of expression, the freedom of every freedom. Thank you very much, and stay tuned for our next session.
Thank you for having us.
Thank you very much, Aja Amina.
Thank you, Idris. You've been our supporter from scratch. Thank you very much.
Yeah, always welcome.